Hello, my name is Raquel Rocky Jones, and I'm the presiding judge of the 203rd Judicial District Court here in Dallas County, Texas.
My name is Thomas Ashworth. I'm an attorney and partner with the firm Lewis and Ashworth. We're a criminal defense firm.
My name is Daniel Lewis. I'm a criminal defense attorney with the firm Lewis and Ashworth.
My name is Delana Griffin, and I am an assistant district attorney for Dallas County. So if you are arrested for a DWI or an offense, what will happen is you will go to jail, go to the county or city jail, whatever jurisdiction you're in, and you'll get booked in. And so that's just a process where they'll have your name and fingerprint you, and you'll get processed. And at some point, depending on the jurisdiction, you may see the magistrate judge who will give you the formal charges against you, and you will get a bond. Most times you'll get a bond from the magistrate judge, and at some point you'll have an opportunity to bond out.
A bondsman will take 10% of the total bond amount, so it's $50,000. Then the person has to pay to the bondsman, generally speaking, about $5,000 to that bondsman. And then as soon as the bond is posted, one way or another, then you get to get out of jail.
You will then appear in court with your attorney, and you'll have what's called the first setting. And so typically what happens at the first setting is the defense attorney will approach the prosecutor on the case, and the prosecutor will provide the discovery, which is just basically the entire evidence file, the contents of the case. And from there, the case will get set every so often, probably on a monthly basis, and you'll, in some cases, be required to appear. And during that process, the defense attorney and the prosecutor are negotiating to see if a plea agreement can be met.
The judge would be the one to preside over any plea agreements that might possibly happen. And I like to tell people, no pun intended, since we're talking about DWIs, everybody has a lane. And you have to stay in that lane. And so the judge is there to make sure that everyone stays in the assigned lane that they're supposed to be in, and that all laws are being followed in regards to driving while intoxicated cases.
Where you generally start with is a plea bargain offer comes from the state. So they make their first offer based on their review of the case, what the prosecutor thinks would be a fair plea deal in their eyes. If you are negotiating with them, if you have a client or a criminal defendant who's willing to accept that they did something wrong, they're going to plead guilty, and now we're just in the negotiation phase. We start talking about, okay, it was an offer for probation. Let's say they offered 2 years of probation. Now we're negotiating about how long that probation should be. Could we change it from 2 years down to 1 year?
A lot of times it does not get to a trial level. So you don't have a lot of, think about the number of cases that are probably filed or indicted even on a daily basis. There's never going to be enough days, enough hours, enough years to trial those cases. So most cases are disposed of by what we would call plea agreement, or sometimes, they have diversionary programs and things like that where the cases don't even come into a courtroom.
If an agreement cannot be met, then the next step would be to set it for trial in the future.
The only cases that go to trial are the ones in which no plea agreement has been reached and the case has not been dismissed.
So the court's role in a DWI or DUI case is judges are umpires. We call balls and strikes. That is the best way I can explain that. We are there to make sure everybody's rights are protected, not just the citizen accused, but also any victims that come before the court. Because with some DWIs, there are also going to be victims because you have DWI accidents.
So some defenses to driving while intoxicated could be where the defense attorney may want to challenge the procedural matter. They may say that some particular rights were violated. They may say that the initial stop was illegal and there was not really a basis for why you were stopped. They may say that there is no evidence that this individual was actually driving at the time or had control over the vehicle. And they also may, more times than not, challenge the validity of the chemical test itself. So if it's a breathalyzer or if it's a blood test, they may challenge the validity of it.
You always absolutely have the right to plead not guilty. Nobody can force you to take a plea. Nobody can force you to ever plead guilty. Every person charged with a crime has the right to plead not guilty and has the right to go to a trial by jury. You can choose a trial by judge if you want to, but typically people go to a trial by jury. A misdemeanor jury typically takes just a day or two.
A lot of defendants would say, hey, I want the judge to be the one to assess my punishment, which would then be called an open plea. And sometimes the lawyers will bring down evidence or bring down witnesses to testify in front of a judge to say, this is why we want leniency. But by that same token, the assistant district attorney can also bring witnesses to say, well, judge, this is what happened in that case. So yes, that can happen. It does not always have to be before 12 citizens on a district level or 6 citizens on a misdemeanor level DWI.
So what the prosecutors will have to prove is that the intoxication caused the accident. And accidents happen for all kinds of reasons. What the prosecutors would have to prove is that but for the intoxication, the accident wouldn't have happened. And that's usually the hardest thing for them to prove.
So the first time DWI, you can expect your license to be suspended for a period of time. You can expect to pay a lot of money in fines. You can expect to be monitored more strictly by the court. So at that point, you're under the court's jurisdiction, and so your travel, for example, out of the county may be restricted. You may have to take and submit to random UAs just to ensure that you're not drinking while on bond or while on probation if your case is resolved. And you also could possibly face jail time.
If you're pulled over by the police, at all times you should be respectful of their requests, but you should also understand that you have the right to refuse their requests if you choose to do so. They're going to ask you questions. They're going to ask you to do certain tests. If you want to refuse, you can do so, but you should do so politely and respectfully. If you want to comply with their requests, you can also do that. It's your right and your choice.
If you refuse the test, your license suspension is longer. You can get an occupational driver's license that allows you to drive during the time that your case is still pending. That's the first thing that you need to do. Then the next thing that's going to happen is that if they drew your blood, which is normally what happens, your blood is going to be sent off to a crime lab to be tested for an alcohol concentration. Once it arrives back at the police agency, they'll deliver the results of that test to the district attorney's office where you were pulled over, and then the case will be filed as a driving while intoxicated offense.
Not every case can go to trial, right? You have those cases that for sure go to trial, but everything else you want to try to see if you can work it out. Especially if it's like a drug or alcohol or substance abuse problem where you think that this person really needs treatment, you want to maybe give them the opportunity to get the resources and help that they need to address this problem so that it doesn't happen in the future.